holding 1 and 2 seem to be the same thing. They're not the same thing. They're very closely related. They appear to be the same, but they're not. They're a little bit different. And you're going to find oftentimes holdings that look very much the same, but they're not. They're literally different. The language is different. The words are different. A little bit different emphasis is it. So don't worry about if they appear the same. They're not. Mike, you had a question?
Yeah, the single point. One of the dicta found here was to specifically identify jurisdiction. The second one was to...
The holdings.
The holdings, yes. Excuse me, holdings, not dicta. The second one was to prevent action by the courts and to justify it. So they would have, one of them would be a positive effect, one of them would be a negative effect, active or passive. That's what I perceived on it. But
well, again, I don't want to get into too much detail, but basically the first one said, without a complaint, the court has no jurisdiction. And the second one said that without the court having jurisdiction, they cannot go on, and they got to be stopped. That's what, in essence, that's what it was. You know, they're very close and about the same, but not necessarily. Okay, let's go on a break. Is it zeroed out? Okay. All right. No, I know they shouldn't.
no.
Okay. Okay. So, how do you guys like reading of Ralph versus Police Court? Was it hard? Was it easy? Was it medium? What was it?
Pretty easy.
Pretty easy? Well, Rob is a little more experienced, but any rest of you, what do you guys think? How was it? Jan?
It's sort of confusing because I needed to get acquainted with it, see exactly who was who, what was what.
Exactly. So the issue is that the first time when you read the court case, you're going to want to know what holding is the one that went for your way. Now, these are the short court cases, by the way, which just makes it easier. Sometimes you come across court cases that are 10 pages long, 20 pages long or more, and you're only interested in 1, 2, or 3 of those holdings. So you're going to go immediately into the holding in the court case first, or in the head notes first. See if it says what you want it to say. Then you go to the holding in the actual text and read it to see if it says what it says, what you want it to say. Then you go back and read the holdings in the court case quickly the first time, get a good feel from it. Then if you want to go back, read it another time, detail. Don't take the time like I did here to read it in detail the very first time. I only did it this way to help you guys understand how they write a court case, what are the different elements and parts of it, its structure of it. It's important that you read court cases quickly and move on, because oftentimes, for example, one of the things you might want to do when you read court case, you say, oh, I like that court case that it says in there. I wonder what it says. I want to cite that case. And you go look up that one. For example, at the end here, this case says, at the very last line says, last court case, even though a void judgment is affirmed on appeal, it is not thereby rendered valid. Right? That's a good one. Right? Now, it's in here, but it would be fine to repeat it, right? So in my oral hearing, that's one of the things I'm going to maybe bring up. I'm going to cite from Ralph versus Police Court. Because I'm not going to assume they read the whole thing closely like I've read it. I'm going to focus their attention, so that's what you do. You bring it up right there to their attention.
To clarify, that was a good example of dicta, where they say when something is affirmed on appeal, it doesn't necessarily render it valid. It's dicta versus holding, which would be in the head notes.
Actually, that would be a good example of a secondary holding, which is necessary to a logical conclusion of the case. It's sometimes a little bit difficult to tell, Eric. That's why it might be a little confusing. But because, you see, that is one of the things that happened in the case, is that it got on... it was on appeal to the Superior Court. It got the motion for arrestment judgment was denied, and the conviction was affirmed, right? And so here they're saying, even though they did that, so what? That doesn't make the court case valid, the conviction valid. So actually, that's one of those logical ones, that logical holdings.
Because this is both a holding, and because it is a direct quote, and because it does have a reading of a particular court case, this is not dicta. This is a holding. Three definitions met.
Well, even if it cites another court case, it doesn't necessarily mean that third condition is not that it's holding. The main thing is if it's part of the necessary logic that the conclusion is based on. If it's necessary part of that, it's part of the question which was really before the court as an element of that, and it's a holding. Let's go to the next court case, which is, if you turn the page over, turn the paper over, case of William F. Gavin versus Municipal Court of San Diego Judicial District. Top of the page, 712. Gavin versus Municipal Court. Short, sweet case. Let's go through this one a little bit quicker. 1. Automobiles, offenses, complaint, criminal law, time of trial. Now, this is also another thing it means is that if you go look in these headings in digests, you're going to find under these headings this court is probably mentioned, and other related kind of cases, you're going to find them under complaint, for example, under offenses, right? It's all there. So let's go number 1. Mike?
A defendant cited for and charged with violating Vehicle Code Section 22107 relating to moving left or right on a roadway when unsafe, who pleads not guilty and does not waive the filing of a misdemeanor complaint, is not brought within the jurisdiction of the municipal or other inferior court as contemplated by Penal Code Section 1382, Subdivision 3, requiring that defendant in a misdemeanor case be brought to trial within 30 days after he is arrested and brought within the jurisdiction of the court until a verified complaint charging him with the offense in question has been filed.
Okay. You read it? The only thing you manage that you got is that without a complaint, no jurisdiction. So it does relate to your subject, right? You didn't get it, don't worry about it. It does relate to your subject, so let's go see what it says.
This is an appeal from a judgment of the Superior Court of San Diego County. Bonsal Noon, Judge, affirmed. Proceeding in prohibition to stay further proceedings in a criminal action. Judgment dismissing and denying petition affirmed. Okay.
Now, it doesn't tell you, for example, judgment dismissing and denying petition affirmed. It doesn't tell you what judge dismissing of what petition. It's not specific. It's not clear what judgment they're talking about. Dismissing, denying what petition by who. It doesn't say it. Don't worry about it. You go on, you'll find out what it is. I'm afraid the courts don't always use good detailed language. They're just summarizing it. You're going to get it in the language of it.
This is an appeal from an order dismissing and denying a petition for a peremptory writ of prohibition and discharging an alternative writ theretofore issued, entered after sustaining a general demurrer to the second amended petition without leave to amend.
You didn't get it? Who cares? Don't worry about it. It doesn't matter. It's one of those things that, when I read it, they're like, I'm not even going to bother. Just go on. Whatever it is, okay? Unless you really want to become a scholar, just go to the beef of it.
The petitioner, appellant herein, was arrested in the city of San Diego on November 25, 1959, for violation of Vehicle Code Section 22107, i.e., moving left or right upon a roadway when unsafe. A notice to appear, usually referred to as a citation, was issued by the arresting officer. Required petitioner's presence before the respondent court on December 17, 1959, was signed by him indicating his promise to appear, was filed, and otherwise complied with the law in the premise. Vehicle Code sections noted. Petitioner appeared before the court on December 17, 1959, as scheduled, and denied that he had violated the Vehicle Code sections in question. On the next day, a verified complaint was filed charging him with the traffic violation for which he was arrested. The petition contains no allegation that he waived the filing of such a complaint. The procedure thus followed was that prescribed by Section 40513 of the Vehicle Code. to the charge contained in this complaint, petitioner entered a plea of not guilty, stated that he would not waive the statutory time that prescribed by Penal Code Section 1382, Subdivision 3, and requested that his trial be set within 30 days following his arrest. Nevertheless, and over his objection, the trial was set for January 11th, 1960.
See, in this case he was trying to make the reverse argument, by the way, this guy. This guy, Gavin, was trying to say the ticket was the complaint. And the time of the arrest was when the complaint was filed, was when he got the ticket. And that he thought that he should be brought to trial within 30 days of that. Of the ticket. You see what I'm saying? And the court said, sorry. The 30 days starts from the time the complaint was filed. The ticket is not a complaint. Your arrest, that doesn't matter. It's not from that date. It's from the day the complaint is filed. So it's more proof that the ticket is not a complaint. Okay, so they're going to, that's the essence of this case, they're going to talk about. Let's go on.
On January 8, 1960, pursuant to previous notice, petitioner moved the court to dismiss the proceedings upon the ground that he had not been tried within 30 days after his arrest, as he contends, is required by the aforesaid Penal Code section. His motion was denied.
See, that's what he's trying to do. He said, I was not brought to trial within 30 days of my arrest when I got my ticket, and the court saying, the time starts running from the time the complaint is filed. So you were tried within a timely basis, so, your thing is, sorry, your argument doesn't fly. You got your trial within 30 days of the complaint was filed, so you had a fair trial. Okay, let's go on. You got a question?
Today, is this the case that a ticket is a summons to appear and not a complaint?
Ticket is not a summons to appear. It's just a ticket is an agreement for you to appear, a notice to appear, just like it says. And notice to appear, commonly referred to as a citation. Yeah, I mean, isn't that nice to kind of remind everybody what a ticket really is, right?
Thereupon, he petitioned the trial court for a writ of prohibition to stay further proceedings in the respondent court. An alternative writ was granted. A demurrer to the petition was filed, heard, and sustained, and eventually a general demurrer to a second amended petition was sustained without leave to amend. The judgment appealed from followed. Finding 1. Pertinent parts of Penal Code Section 1382, Subdivision 3, provide that the court, unless good cause to the contrary is shown, must order the action to be dismissed in the following cases. Sub 3. When a defendant in a misdemeanor case in an inferior court is not brought to trial within 30 days after he is arrested and brought within the jurisdiction of the court. Emphasis added.
Okay, that's pretty clear language, I would hope. You guys notice those 3 dots they use in there? Ellipses they call them. That is a very useful tool you notice the court uses, and I hope you use it in your writings too. When you want to bring only the relevant portion of a law, court case, whatever you want to quote, use those 3 dots to get rid of the garbage language that makes it confusing and get to the essence of what you're trying to talk about. So you see how they're using it here? See also how they're using italics to emphasize? You ought to do the same thing when you want to emphasize something. Use bolding as well. Italics, bolding, underlining, you can really have a good time emphasizing for them. It's don't overdo it, but do use it. The courts do it too. Let's go on.
Petitioner was arrested on November 25, 1959, and contends that he was brought within the jurisdiction of the respondent court at that time. A similar contention was considered and rejected in the case of Ripley v. Johnson, which held that a defendant cited for and charged with violating a vehicle code section who pleads not guilty thereto and does not waive the filing of a complaint is not brought within the jurisdiction of the court as contemplated by Penal Code Section 1382, Subdivision 3, until a verified complaint charging him with the offense in question has been filed.
That's another case, by the way. I didn't put in this package, Rupley versus Johnson, where, you're not brought within the jurisdiction of the court until the complaint is filed. Isn't that lovely? Okay. By the way, I should, on a side note, make it a little interesting, I should tell you. I got a case myself recently, just 12 days ago. I had three notice to appears in California. And one was in San Bernardino, one is in LA, one is in Kings County, in the middle of up the 5 freeway on the way to San Francisco. I appeared in San Bernardino on a continuation, and the clerk scheduled me on a date the judges don't hear cases, and they refused to allow me to see the clerk, see the judge. And I got a letter, a stamp on the back that I was there. Well, the San Bernardino court insists that I got to come back then, even though I've appeared. Instead, they report me to DMV as not failing to appear, suspending my license. I've written to the LA and the Kings County courts asking for if there's a complaint, I'll be happy to show up. Send me a copy. Well, they didn't do that either. Even though I sent them, in fact, copy of these laws to the LA one, I actually sent the guy these copy of the law, and they reported me as failing to appear, reported me to DMV. Now, has any trial been held that I'd failed to appear to the court?
No.
Has there? No trial has been held that I failed to appear. So there's really no judicial ruling. And in violation of a separation of powers doctrine, the judge's clerk enters the failure to appear on the computers of the DMV, the executive branch. So here we have the executive, the judicial do the executive job. Okay, on top of that. Now, you see all these violations, every step. Now, there's no jurisdiction because there's no complaint, right? In fact, the one in San Bernardino, I even showed up. And they still wanted me to come back and prosecute myself, right? Basically. And then they put it in the computers at DMV. And the DMV doesn't give me any hearing when I asked them before. Now that they was driving around with my car, they seized it. The CHP stopped me, seized the car, in fact, a couple dozen days ago. And they have a minimum 30-day impound. Now, so, the suspended license. Now, these cases are over 2 years old, which by speedy trial of case of Rost and Cerna, anything over 1 year old is too old, by the way. Anything over 1 year old, sorry, too old. There's no, even if it is there, it's got to be dismissed. But the punishment of suspended license and the punishment that comes after that is all there still, right, on the DMV computers. Now, the cop comes and takes my car, the CHP, gives it to the tow company, a third party. The third party takes my property and demands that I pay him storage fees. And after 30 days, if I don't have my driver's license out of suspension, they can still keep the car and sell it to the third party for whatever they want. You know what's that like? The state comes after Tom here, okay, for whatever. And the sheriff says, Mike, tell you what, I just got Tom here. Why don't we put Tom in your house, Mike, for jail? Okay? And I tell you what, Mike, you get to charge Tom rental for him being in your house for jail. Now, does Mike have any authority to be a jailer? Does he? No. He's not a jailer, right? So the towing company has no authority to act for the government either. So the government, if the sheriff wants to jail you, they got to take you to their own jail, and they got to pay for your room and board, right? So the CHP wanted my car. They got to go tow it themselves to their own impound, right? And don't ask me to pay for them because they're storage, right? Well, you see how they're enriching a third party? So they get to be fun because I'm filing this week my civil rights suit against the towing company and the CHP officers involved. And doing a writ of mandate against the DMV and the courts and CHP in the Supreme Court of the state because I have standing to go to the Supreme Court because all these three different courts are not only in different superior court jurisdictions, they are in different court of appeal jurisdictions. No one court of appeal has all these three courts under its roof. In fact, they're all of them on three different ones. It's an important question of law. Affects, obviously, lots of Californians, right? So this stuff gets to be fun. It wasn't a battle I really wanted, quite frankly, because I got my hands busy. But then I got it. I want the car back, and so it's good to be. So this stuff, when it happens.
You don't want to pay ransom to get it back.
That's right. Now, well, they're not going to.
Ransom.
Even if I pay them ransom, they're not going to give my car back. Because they say you don't have a valid driver's license. And there's been no court ever held convict me of anything. All this CHP officer in the hearing that we had when he says, go on a computer printout of the DMV. If that shows your driver's license was suspended, good enough for us. That's it. On a computer. That's hearsay printout. That's trial by computer. Thank you. And the DMV, of course, I called them immediately. They repeated, we're not going to give you no hearing. Go to the courts. So nothing held, deprivation of property.
It just so happens, Payman, I have a client, and this happened to him 2 weeks ago, and I have the code right here on this specific issue, your problem. Okay, so I want to ask you this question: did you receive certified mail from the impound yard yet?
I don't know if I did or not, because the address that the officer took was actually old address, which was changed, and if they did or not, and I don't want to get them on that little technicality.
Well, there are.
I know they got to certified. I know they buy within 48 hours. They got to send you.
Charge you for 15 days.
Yeah, I know all that. I know all that. Oh, yeah, I've done all the research on that, but I want to get them on the main issues like we got here. Okay, and your friend Lou on that subject can do that, you see. But why should your friend even pay 15 days of storage if they did not pay the certified mail? I know, but let's not get off the track.
Okay.
But the point is that you see how this ramification of this stuff goes on. And where do they stop? They don't stop any place. We got, when they just take your property, and until you put them back into place. So, and I tell you, we're having fun. Rich just here. Told me that I was at his franchise tax board hearing we conducted. Rich, was it a year and a half ago? Is that about right?
November of
96. That's about a year and a half ago. He did his board of and board of equalization requires him to have his hearing heard for him to file a return, and by filing a return, he's waiving his right to a hearing. So we're having fun. Huh?
But the act of when the BOE asks for a return as part of your appeal process, just the act of signing the return removes jurisdiction from the BOE.
Oh, that's right.
Now they can't hear it.
They can't hear it.
It's catch-22. We want the return so we can hear your return, so we can hear your appeal. If you sign the return, you lose the opportunity to have the appeal.
That's right. You don't.
It's out of their hands.
Exactly. So it's this fun. I'm really excited because we're having fun stuff with some of our students like Rich are really taking these guys head on, and the spark's going to start flying pretty soon, you guys.
Let me give you a quick synopsis of this case. Real quick, you want to hear unconstitutionality. He did not know he had a suspended license. He didn't come to a complete stop. A stop sign cop pulls him over in Redlands. Okay, gives him a citation. Finds out his license was suspended in 1995 for a failure to appear for a ticket, speeding ticket. Okay, make a long story short, they seize the car on the spot, make him walk 6 blocks. Okay, the very next day he gets a court date. So he appears, and he pays the fine, the outstanding fine from 1995. Now he's got the abstract from the court to take to DMV, a court order to get his car released. Okay, the Redlands Police Department will not release the car for 30 days, and the law is clear, it's black and white, and they're violating the very law, the very vehicle code that is right here.
That's right, because the law does say that the court upon court order they ought to release the car. That's true. Well, you guys, this is why we're going to get into civil rights suits against government officials.
That's what we're working
Because
on right
I
now.
tell you, and that's why I really want to bring Sean down here to do a full 2-day seminar. Because they're violating the law, and unless and until we sue them and nail them, they're not going to learn their lesson. That's what needs to happen. Okay? Okay, so let's get back to where we left off. Where we leave off, Mike? You know where we are?
In the cited case.
Okay, what paragraph where we are at? We're in the middle of the...
Almost the exact middle of the second paragraph
Okay.
inside the entire unit.
Page 714.
Page 714. The court in the cited case based its decision upon the provisions of the Vehicle Code, which then were contained in Section 739.1 thereof, but which now, without material change, are set forth in Section 40513 of that code.
See how they gave you a little history? They told you 739.1 of the vehicle code has been put in 40513 as of back then, which was 1960, without any change. They just put it some other place, no change. The major change appeared in 1968.
This decision is determinative of the issue presented to this court. Also in point are the cases of Ralph versus Police Court and People versus Agnew. The complaint against petitioner was not filed in the respondent court until December 18, 1959. The criminal proceeding, which he sought to have dismissed, was not pending in court until the complaint was filed. The trial date of January 11, 1960 was within the 30-day period prescribed by law. Petitioner cites and relies upon the decision in Herrick versus Municipal Court. This case is not in point, in that the petitioner therein was arrested on April 3, 1956, for a violation of Section 502 of the Vehicle Code. A complaint charging him with that violation was filed in court on April 6, 1956. He entered a plea of not guilty, and the case was set for trial on June 8, 1956, over 2 months after the complaint had been filed. The holding of the trial court in the cited case, insofar as it considered Subdivision 3 of Section 1382 of the Penal Code, was confined to a determination that a defendant who has not been tried within the 30-day period is entitled to a dismissal of the action against him unless good cause exists for the delay and is not authority for the proposition that the petitioner there under consideration was brought within the jurisdiction of the traffic court at the time of his arrest.
See, at the time of the arrest, he was not brought into the jurisdiction of the court. And 30-day did not run. So they're saying that this court case of Herrick you're trying to use, Mr. Gavin, doesn't apply. Okay, that's all it was. As far as you are concerned, the previous paragraph, they ended what you were interested in. They were just dismissing his other last argument, okay? So it says the judgment is affirmed, and then it goes Griffin, presiding judge, and Shepard, judge, concurred. Appellant's petition for hearing by the Supreme Court was denied November 16, 1960. So, the decision of the Court of Appeal stands. Let's go to the next page. We get a case of, turn the page over, Anger versus Municipal Court. The top on the right page, September 1965. This is the latest case that says this kind of about the ticket is not a complaint, kind of a jurisdiction. Turn the page over. On top of the page says 69 on the top right, Anger versus Municipal Court. Turn the page over. This was the last case that's before 1968 that said a ticket is not a complaint. After this, they changed things in 1968 to give the appearance that you're not entitled to a complaint. If the ticket is one which is approved on a form approved by the Judicial Council. Okay, but it's not so. That's just confusion they've created. So here we go again. You see civil case number 22512, 1st District, Division 2, September 15, 1965. George M. Anger, plaintiff and appellant, versus the Municipal Court of the City and County of San Francisco, defendant and respondent, the people, real party and interest, and respondent. By the way, you guys know City and County of San Francisco are one. It is a charter city and county. And one. What does that mean? Yeah, what does that mean is that whatever law they make there in San Francisco, it supersedes the legislature. Because they got their own legislature locally. Yeah. Check in California and many other states that have similar provisions, the local county or city which has chosen to have its own charter, like its own constitution, under its own charter, which is like its own constitution, any law they make supersedes the state law. It does not supersede the state constitution. So it's like having your own little country within a country. Local control. They were always meant to be. So in San Francisco, they got their own socialism the way they want it, just like in L.A. L.A. City is also a charter city. That's why they get so much power. That's why you hear on radio, LA City Council said this and that. Very important, because for the people in LA, that's their state legislature for the most part. Okay? Anyhow, without getting sidetracked, let's go to the holdings and read that. Mike?
1A, 1B, automobiles, prosecutions, jurisdiction, criminal law, jurisdiction, municipal courts. The municipal court did not acquire jurisdiction over a driver who, in response to a traffic citation for fail to yield a right-of-way, appeared through his attorney and pleaded not guilty, where, though the matter was set for jury trial, the charge was dismissed on the prosecutor's motion without a complaint being filed. 2. Criminal law, former jeopardy. Legal jeopardy does not arise where the court has no jurisdiction.
Let me tell you guys what this case is about, so you know, a little bit easier for you. This was a case where this guy hit somebody, okay, with his car, and I don't know, he failed to yield right away. He was given a ticket at the time for failing to yield. Well, later on, they prosecuted him because the person that he hit died. The pedestrian died. Okay, poor thing. And they start prosecuting for the death. And they